and Digital Media Ethics Code Rules 2021. Before beginning, I would like to brief you all about the IP Press. The IP Press is a team of IP holics who started this blog to ensure that the latest intellectual property issues for all the IP hopefuls. Our focus is to address the IP concerns of stakeholders, students, academicians, researchers, startups, etc., and to guide them to attain and enforce their IP rights. We not only hold expertise in law and intellectual property, but our team of technically skilled professionals, IP specialists, and patent agents give us a better understanding to deal with the technical issues in intellectual property. To focus on national and international issues, we are supported with international IP experts as well. You can check out our website www.theippress.com and follow us on Instagram, Facebook, and LinkedIn to get the regular updates. I would now like to play a short video about the IP Press. Before beginning with the session, I think there is some issues with the video, so we'll just carry on. Before beginning with the session, I'd like to get you familiar with this platform, AirMeet. The platform provides an option for attendees to ask questions in the question box. Moderator will check the question and ask it from the speaker. If some attendees wish to ask the same question, they can simply upvote the question by clicking on a like button appearing below the question on your screen. This will give us the importance of the question and we will be asking the speaker accordingly. In case there is any attendees who wish to interact with the speaker, there is an option on the screen to raise hand. If you click on that option, the moderator will allow you to enter the stage with the speaker to interact publicly. You may also interact or discuss in the chat box appearing on the screen to answer, discuss, or interact with the speaker and other attendees in public or private chats as well. Now, I'd like to welcome our keynote speaker for the day, Advocate Abhishek Nangia. Mr. Abhishek is a partner with RNA Technology and IP Attorneys, and he joined RNA in 2009. He is a seasoned professional in advertising clients on diverse sectors on a wide range of intellectual property and information technology issues and involving e-commerce regulations. Mr. Abhishek is an expert on advertising media clearances, legal framework, and practical issues surrounding misleading advertising practices in India. He regularly writes articles which have been published in print and electronic media, including the Inishi magazine published by the Japan Patent Office, and has also been invited to address law enforcement officials, law institutes, and various other organizations on IT law, IP enforcement, and IP issues in cyber law. We are really glad to have you, sir, with us today as a trainer of our workshop. Now, without further delay, I would like to call Mr. Abhishek on the stage. Over to you, sir.
Thank you, Himani, for the nice introduction. And am I audible?
Yes, sir, you are perfectly audible.
Thank you. That was a very nice introduction to start with, and a very good afternoon to all of you. It's indeed a pleasure to be here and interacting on this very interesting topic, which has grabbed headlines in the past 3 months and is one of the most talked about topics. And even until today morning, there was an article in the newspapers. So it's a topic, which has caught attention of everyone, and I think it's a perfect setup, to have a discussion on this. And to start with, to give you the background of what I will be discussing, the topic is the information technology, the intermediary guidelines, which had of 2021. And in today's session, we will be talking about the practical issues surrounding the IT rules, which were introduced in February 2021. And I have a very short presentation, so discussing about the salient features. What was the background actually which led to this? Why were these IT guidelines introduced in the first place? Then, how has the response been ever since they were introduced? We have seen the guidelines being covered quite extensively in the past 3 months, and not even a single day has gone when this has not been covered, either in the newspapers or the internet. You open the internet, there's an article every second day about it. And also we will discuss about the criticism, why these IT rules have been criticized, the litigations that have been filed in various parts of the country. So, not holding you any longer, we will kickstart the today's session, and in the end, we will have the Q&A round. I'll be most happy to answer any questions that you may have on the today's topic. So, I'll be sharing the PPT. Are you able to see my screen?
Not yet. We are not able to see the screen.
Are you able to see it now?
Yes, sir.
Perfect.
Okay.
So let's begin the today's session. The topic, as I mentioned, is the IT guidelines of the IT rules of 2021. Now, before we begin, it is very important to understand why these IT rules were brought about. The background is that then in the last year, prior to this enactment of the IT rules, the OTT players, they had signed a self-regulation code to govern the content which was shown on the platforms. But this code was eventually rejected by the government. So, in February this year, the Supreme Court put a question before the government asking what were the measures that were taken by them to regulate the content on OTT platforms. And considering there was a there was a PIL file in the Supreme Court alleging that the Mirzapur web series had tarnished. Where it was not shown in proper light, and it was shown as a city of goons. So, with the question being put before the government, what were has some legislation been enacted? So, the government, in this background, brought the 2021 IT rules, and these IT rules were given the name of Intermediary Guidelines and Digital Media Ethics Code, as you can see on this slide. Now, coming to the next question, as we move along. What was the need to introduce IT rules? There are several reasons, and the first reason is there was absence of an institutional mechanism to deal with the content which is shown on the OTT platforms and the digital news portals. Now, when I say this, what I am trying to refer is that there is a legislation for instance, for the news in the newspapers, we have the Press Council of India Act. Then the news on the television is governed by the Cable Television Network Act. For the cinema halls, we have the Cinematograph Act. For the film and the web series, we have the Cable Television Network Act. Now, when we talk about the news on digital media and the OTT platforms, there is no regulation at all. And this eventually was one of the reasons which led the government to think on these lines, the requirement for framing the IT rules. The second reason, and a very important reason, was the rising number of complaints that were received on the language and nudity of the content shown on the OTT platforms. I think one thing we all would have seen, the content which we all see on the OTT platforms is of foreign origin, and the ratings which are given to the content which is shown, they actually may not be applicable in India, taking into account the cultural differences. And the content shown on the OTT platforms is watched by people of all age groups, including the children. And the young children, they are at an impressionable age. So, looking at the content which is shown, they are bound to form an impression on the content which is shown. Another reason was the rising number of FIRs which were filed against the several web series. We had a number of legal proceedings being initiated, and for example, there were several instances, and the web series such as Tandav, Mirzapur, Patalok, and Sacred Games. These are just a few, and there were several complaints, and these complaints were actually rising. And the complaints were based on hurting the religious sentiments, or maybe the violence or the abusive content that was being shown. So another reason which led to this was the rising number of the FIRs being lodged. And when we look in the international practice, what is being followed in the other countries, this was, several other countries had actually taken steps to regulate the content that was being shown on the OTT platforms. So these guidelines, or rather the rules which have come in February 2021, they have been enacted under the Information Technology Act of 2000. And the social media companies were given 3 months time from the date they were introduced to comply with the rules. And the 3 months time expired on 25th May 2021. And ever since these 3 months have expired, these IT rules have been in the news since then. Every day, some issue or the other with the social media companies flagging it about the provisions, or we will have a discussion in detail as we go along. But these have grabbed the headlines ever since then. Now, let us try and understand first the basic features before we go deep into the IT rules. These IT rules have replaced the intermediary guidelines of 2011. And the scope of these guidelines is much more, because they now regulate the content on the OTT platforms and the online digital news content. And these guidelines basically now cover the digital social media platforms, and it also provides an ethics code for the online curated content, which we commonly call the OTT platforms. I'm sure all of you would be familiar with the OTT platforms. Just in very simple terms, if I had to give a definition of this OTT platform, this would be a content which is, content which we see through the internet, which by using the internet. And during the pandemic, the growth of OTT platforms has been phenomenal. Uh, and the one of the the key reasons is, all of us were confined in our homes, and with the stay-at-home orders, we actually spent more time with our families and on the OTT platforms, and than any other thing else, because we could not move out. And the content shown on the OTT platforms, you have everything, and it's for all people of all age groups. It could be sports, history, geography, even movies were released. I think this was the first time when we actually had movies being released on the OTT platforms. And if somebody would have asked 5 years back, do you see the OTT platform have with the movies being shown on OTT platforms, no one would have even ever imagined. So such has been the growth, and with the growth, there was a need, to have something in place. And the examples of the OTT platforms, they are Netflix. I'm sure all of us are familiar. Lockdown has made us all these terms, made us quite familiar with Amazon Prime, Hotstar, and in fact, you will be surprised to know the viewership of increase of the Hotstar tripled in 2020. So such has been the phenomenal growth of the OTT platforms. And the news portals, the news aggregator, news agency, they are the publishers of the news and current affairs content. So these IT rules, they provide an ethics code for the publishers of the news and current affairs content, and we will discuss more in detail. So this was just to give you a background of the flavor that we will be discussing today. Now we will be discussing about the key features. I have summarized them in 4 points. These are the four basic features of the IT rules. The first one is the due diligence by intermediaries. The code of ethics for publishers is the second. Third one is the three-tier regulatory framework which has been set. The fourth is the disclosure of information. Now we will discuss each one in detail and try and understand what this is all about and why this is, making headlines every other day. If the OTT with the IT rules, if they are so clear, but what is the reason why this has caught the attention of everyone? So let us try and understand each feature one by one. So the first point that I'll be discussing today is the due diligence by intermediaries and the significant social media intermediary. One thing to keep in mind is the distinction that these rules have made. The distinction has been made on the basis of the registered user base on the social media platform. And the distinction is, if there are more than 5 million registered user base in India, it will be classified as a significant social media intermediary, and below this will be is defined as an intermediary. So the rules, when they talk about the due diligence for an intermediary, they say that the privacy policy and the user agreement which is there on the website, uh, it shall in express terms make it very clear that the users will are not allowed to share, or rather they will not share any information which threatens the sovereignty of India, any information which is affects or has an impact with the friendly relations with foreign states, or which may have an impact on the public order, or something which is defamatory, obscene, pornographic, or is an invasion of privacy, or something which is harmful to children and infringes intellectual property rights. The user is not allowed to share any information on the points which I have just discussed. And one important thing to be kept in mind is that this information, which when it is brought to the knowledge of the intermediary, the intermediary is required to bring it down within 36 hours. The important thing to note here is the use of the words actual knowledge. So which in other words means that if a user somewhere posts something, the intermediary cannot be held liable just because it has been put up on the website. So the timeline of 36 hours only starts when it is brought to their attention, which is in the form of a court order or through a government agency. So the timeline starts only then and not otherwise. Now, the grievance redressal mechanism, how the grievances are to be addressed. This was one of the basic issues, why these guidelines were introduced. It was felt that there was no proper mechanism to file the grievances. Now, what these IT rules have actually done, they provide very strict time frame for the filing of for filing and the decision to be passed on the any grievance that is filed. So it says that the complaint has to be acknowledged within 24 hours and to be decided within 15 days. But when it pertains to a complaint, when it pertains to any obscene material that is posted, it has to be removed within 24 hours. So such is the urgency which has to be shown when the content pertains to any obscene material or information that is uploaded on the website. Now, let's understand, discuss in detail about the significant social media intermediary. As I mentioned, there is a distinction which has been carved out in the rules between an intermediary and a significant social media intermediary on the basis of a registered user base in India. Now, these rules actually place, a higher threshold for a significant social media intermediary. They are required to appoint 3 officers, and these 3 officers have been named as the grievance officer, the nodal officer, and the chief compliance officer. And all 3 of them have a different function. The grievance officer is the contact point for receiving any grievance that is filed by the user over the content which is posted on the platforms. The role of the contact nodal officer is to coordinate with the law enforcement agencies, and the chief compliance officer for ensuring his role is to ensure compliance with the IT Act and the rules framed under. Now, the rules mention that the all these 3 officials, which you can see on the screen, they have to be a resident in India and on the payroll of the parent company. Now, in the last 3 months, there has been a lot of back and forth and an exchange of correspondence with the government over the appointment of these 3 officials. The very interesting example which comes to my mind is of Twitter. They the rules are very clear about the eligibility criteria, which says the resident in India and on the payroll of a parent company. Now, in the first place, when the 3 months had expired, the government reached out to the social media intermediaries, asking them that what about the appointment of these 3 officials, which was required to be made. In response, what Twitter did was they appoint an official not from the company but who was working in a law firm. The government rejected the appointment of the grievance officer and said this is not acceptable because the grievance officer has to be someone who should be on the payroll of the parent company, not an external person. Since he was working in a law firm and was a lawyer, the government didn't accept it. So again, this was not in line with the IT rules. Next thing, what the Twitter did was they appointed a person of Jeremy Castle was the name of the individual, and he was a US national, and the address mentioned was of US. Again, this became a bone of contention between the government and the Twitter, because it says he has to be a person who is a resident in India in the payroll of a parent company. Again, this was in conflict, not in IT rules. And now, finally, the Twitter has appointed an person who is an Indian national, and they have appointed the grievance officer who is an Indian national. And I was reading this today morning. The Twitter has also appointed the nodal officer and the chief compliance officer. After a lot of back and forth, how these appointments have to be made. So they have appointed all 3 officials, although the names are not appearing, but they have submitted in the court that they have actually appointed these three officials in line with the requirement of the IT rules. Although the names of the nodal officer and the chief compliance officer are still not available on the website, but they have made a submission before the court yesterday that they have actually appointed. And likewise, when you talk about the other social media intermediaries, WhatsApp and Facebook, they also have appointed the grievance officer. The details are now available on the website, so, so that if someone has a grievance, he can be contacted for over the if someone has a objection. Uh, when we talk about Google, another issue is which we will talk about in detail later. The Google mentions the name of an officer, but he's not an Indian. He's not residing in India. It mentions the name of a foreign national, and the address mentioned is of US headquarters. Again, the Google is also challenging these IT rules. We'll talk about later when we talk about the litigations that have been filed. So again, these appointments are being made, and slowly these official appointments are being made, but on the other hand, we have a lot of litigations that have been filed. Another uh, ground, or the threshold which has been mentioned only for a significant social media intermediary is the monthly reports that have to be filed or have to be shared with the public about the grievances that have been filed, the actions taken. I think very recently Twitter came out with their first report. Likewise, WhatsApp also came out with their first report. The number of complaints that were filed before them and the action taken. So the data has to be shared. These are the compliances which they all have to do and share the data about the complaints and the action taken. Importantly, the action taken as well. Now, another very important provision of the IT rules is the traceability clause. This has been in the news ever since the IT rules were enacted. And let us try and understand why. Firstly, what is a traceability clause which is provided under the IT rules, and why there is a lot of objection, or the why this is being talked about on a almost on a daily basis. Now the significant social intermediary, providing messaging services, uh, they are now required to identify the first originator of the information when there is a court order or an order passed under section 69 of the IT Act. The section 69 of the IT Act mentions about, there are certain categories when the government, when there are reasons such as the sovereignty of India, if there is any information or content regarding the sovereignty of India, security of the state, friendly relations with other countries, public order, or incitement of an offense, uh, they can ask the significant social media intermediary to decrypt the information. Now, what does decrypt and end-to-end encryption means? Let us try and understand firstly what is the basic meaning of these terms. End-to-end encryption means, whenever see all of us would have, we all use WhatsApp on a daily basis to make voice calls, or to send communication with each other. The You would have noticed that it mentions end-to-end encryption whenever you make a voice call or a video call, which means that even WhatsApp does not have access to the communication that is being exchanged between the sender and the receiver. So if this has to be done, this will break end-to-end encryption. In other words, for to decrypt the information, if this kind of information has to be shared, this will lead to there will be implications about it, and the stakeholders have expressed concerns about the traceability clause, that they will have to make changes to their platform, and to the business model which they are doing, and they do not know what kind of what message will be subject matter of tracing order, because the words used here are very wide and they are very although the sovereignty of India, security of the state, when we talk about these words. So there is an apprehension which the industry has expressed that they could be, uh, they actually do not know which message would actually form a subject matter of a tracing order. Then another thing which the significant social intermediaries are required is they are required to deploy automated tools, to identify any information which depicts any sexual activity, sexual abuse, rape, or any information which has been uh, that has been previously been removed. So they are required to deploy some tools. They some have some algorithm in place to have this content removed, because we this content should not be there on the platform. So some proactive steps or techniques have to be adopted by the significant social intermediaries as well. Now, a very fundamental question comes and is often asked: what happens when these steps are actually not taken? What is the implication of it? The first implication is that the intermediaries lose the safe harbor immunity. The Section 79 of the IT Act talks about the safe harbor immunity, and in simple terms, which it means that if they do not comply with the due diligence provisions, which we have just discussed for an intermediary and a social significant intermediary, they can be held liable for any third party content posted on their platforms if they do not take these steps. So all of us would have heard, the government was making the statements when the appointments were not being made by the social media platforms, the Twitter, the WhatsApp. Initially, when these platforms they had not made, although they have now done it, they are in the process of doing it. Twitter has done it very recently. So the implication which was being talked about was that they will lose the safe harbor immunity. So meaning that they can be held liable for any content which is posted on the platforms. Another implication is the civil and the criminal liability. The rules expressly make it clear that if these provisions are not adhered by the social media platforms or the intermediaries, they will be held liable. There will be civil and a criminal liability for the non-compliance of this provision. Now, let us talk about the OTT platforms. As I mentioned in the beginning, there has been a phenomenal growth of the OTT platforms, and the pandemic has just accelerated the growth of the OTT platforms, and the digital push by the pandemic has uh, uh, has got everyone hooked onto the OTT platforms. Now, the rules have laid down certain principles or the guidelines which the OTT platforms are now required to observe uh, as per the IT rules. So now let us see what are these guidelines which have been prescribed under the IT rules. Firstly, the platforms will not publish any content which is prohibited under any law, or any content which has an impact on the sovereignty or the integrity of the country, or something which has an impact on the security of India. Thirdly, any information which is which may have an impact on India's relationship with relations with other countries, or which may have an impact on the public order, or something which may incite violence, may cause unrest. uh, Such kind of content will is cannot it should not be shown. Another thing which has to be kept in mind is the multi religious context. Keeping in mind we have different religions in India, the content which is shown has to keep in mind the religious connotations and the multiracial, the different the racial, any implication that it may have, and any beliefs, or the any religion or the group. So something in general. So you will see that these are the basic guidelines. The IT rules now have laid a basic structure uh, for the OTT platforms regarding the content that can be shown or cannot be shown. Another thing which the IT rules talk about is the content classification. Now, the content has to be classified, which is based on the following parameters. So these parameters are the violence, nudity, sex, or the drug and substance use, and the horror, and the description of the content. This has to be shown before the program actually begins. And the purpose of doing this is that so that the user or the viewer can actually take a decision whether he should watch it or not watch it. The classification rating which I have mentioned on the slide, I think it is in the next slide. Yeah. So you will see this is a age based classification that has been made. And there are five categories now which have been categorized for the content that is to be shown on the OTT platforms, and these are based on the for example, if people of all age groups can see, it has to be given a U rating, and for 7 years and above it will be 7 plus, although it can be watched by someone who is lesser than 7 years but with a parental guidance. Likewise for other age groups, 13 years and 16 years. But and however, content which is specifically restricted to adults has to be given a rating. So this description, and as we see here in the previous slide, and the age, they have to be mentioned at the beginning of every program. So uh, these are the age based and the content descriptor. This has to be shown on the just before the program actually begins. Now, a very interesting and uh, the three-tier structure of the digital ethics media code needs mention and a discussion, an in-depth discussion. As you can see on the screen, this is a three-tier structure as we call it. The level one is the grievance redressal, grievance redressal. Level two is the self-regulation by the self-regulation bodies of the publishers, and at level three is the oversight mechanism by the central government. And this is when I talk about the ministry, I refer to the Information and Broadcasting Ministry of the Government of India. So this is the three-tier structure. This three-tier structure has actually been in form for the purpose of addressing the grievances. Now let us understand each level in detail. This is the broad structure that has been laid out, and let us see what this is all about. And this has been talked about, and what has been the response of the media companies to the three-tier structure which has been enacted. But before this, we will first understand what this is all about. Level one is the publisher. The they are required to appoint a grievance officer, and again, this is it lays down very strict timelines for the resolving the grievances. Uh, this is a there is a very time bound acknowledgement, and the grievance has to be resolved within 15 days, and the user or the complainant has to be provided details of any action which is taken or not taken, or in other words, the decision has to be communicated to the complainant. And the details of the grievance officer have to be made available on the website of the publisher. So now we talk about the level two. Level two is the self-regulating body, and this self-regulating body will again be constituted by the publisher. And this is again a body, this is an independent body, and publisher is will also be a member of this body. And one thing to be kept in mind when I had discussed about level 1 in the previous slide, uh, the appeals from level 1, or if the complainant is aggrieved by the decision passed by at level 1, it can be escalated by filing an appeal with the level 2, that is a self-regulating body. This self-regulating body will be headed by a retired judge of the Supreme Court, High Court, or a person of eminence, and it will have members from the various fields. And this self-regulating body, once this is formed, this is to be registered with the government, and again there is a timeline for the complaint to be decided. Like we had 15 days in level 1, the same time period we have in level 2 as well for the as a timeline for deciding the complaint. In case the complaint is not decided within 15 days, the matter now reaches to level 3, which is the oversight mechanism by the central government. Now let us look at the powers which these self-regulating bodies have, which are under the IT rules. They have been given certain powers, what the action which they can take when a complaint comes to them. They can issue a warning to, or a disclaimer to the publisher, ask him to change the content, make some changes, or ask for some apology to be ask for some apology from the publisher. Another could be to reclassify the ratings. As I just mentioned, the ratings that we now have the age based ratings under the IT rules, and the content description, there are certain parameters which have been, so they can ask the publisher to make certain changes in the description of the content. These kind of some changes they can ask them to be made. Another the advisory which can be issued by them is, they can refer cases to the INB ministry involving any content which has an impact on the public order, or any circumstances covered on the section 69. Section 69 essentially, as I had just discussed, it empowers the government to block the content whereby something which may have an impact on the sovereignty of the country, the defense of the country, the security friendly relations with the states. In general, it is the national law and order, law and security. When we talk about section 69A, empowering the government to the block the content. Level 3 is the oversight mechanism which has been developed. Here comes the role of the central government. Now, you would have seen level 1 and level 2, the government was not involved. Level 3 is a stage where the government is involved. The earlier level 1 and levels 2 stages, what they were actually handled by the publisher itself, and the government was nowhere involved. So at the top we have the level 3, where the role of the government comes into the picture. Now the information and broadcasting ministry, the government, they are required, they actually they are required to establish the departmental committee, as we call it under the rules, to adjudicate the complaints or the grievances that come before it, which may be arising from level 1 and level 2, as we just discussed earlier. Also, the INB ministry will develop a charter for self-regulating bodies. The charter will be the guidelines, for the self-regulating bodies that we talked about in level 2. And also, they issue guidelines and advisories to publishers from time to time, for complying with the code of ethics, which is a part of the IT rules. And lastly, take action for non-compliance. If somebody does not comply, take actions for not complying with it. And the role of the interdepartmental committee is to hear complaints, and they can make for recommendations, and the recommendations which, or the powers, as we may call it, these are the powers which they have. For instance, issuing a warning to the publisher, asking, seeking an apology, any changes in the ratings or the description in the content, any changes in the some if there's some changes to be made in the content, any content which is objectionable and should not be shown, or something which may have an impact on the public order, and or something which should be blocked, keeping in view the circumstances that are provided under Section 69 of the IT Act, which empowering the government to block certain content which has an impact on the sovereignty and other factors, security of the state, friendly relations, which we just discussed. So essentially, these are the three categories which have, or the three levels which have been enacted under the IT rules. And the three-tier structure, there has been a lot of discussions ever since the IT rules have come about, and till date there has been a mixed response. Some have said these IT rules should have come much earlier, or this was the need of the hour. But some have criticized it, that these contain provisions, it goes much beyond the IT Act. And so till now, this actually, we have seen a very mixed response to the IT rules which have been enacted. The One of the reasons is there has been the oversight mechanism which has been established at level 3 is being talked about more often than not. The stakeholders have taken a view that this is without a legislative backing. The oversight mechanism, which is at level 3, it goes much beyond the scope of the IT Act. This is the view which has been taken by some of the stakeholders. Another view is that the oversight function, when we talk about level 3, which is the final, actually, the chief regulator, where the government assumes the role of a chief regulator. This will be, actually comprising of the officials from the ministry, from the various ministries of the government. So we have a body which comprises of the bureaucrats, and it is not likely to be autonomous. So it will have, the composition will be of the bureaucrats at the level 3, and being at the top, they actually will have they will be in a position to decide what should be shown or what should not be shown, because this is the final authority in terms of the hierarchy that we see at level 3. So they actually decide what should be shown or should not be shown. And when this happens, it is likely, or it may have an effect, a chilling effect on the freedom of speech and expression, thereby meaning that certain content which the bureaucrats or as the government may find it, may not actually be shown on air. So it will have an impact on the freedom of speech and expression as well. Now, when we talk about these IT rules, it's very important to understand, are these rules different, or what sets India apart? Why is there a lot of hue and cry? What actually makes them grab headlines every second day? We have something or the other, or a new litigation which is coming up. There are few reasons behind it, which I feel what sets these apart. The first is the significant social media intermediary could be ordered to decrypt the information even by an executive order. When we talk about the traceability clause, which I had discussed few moments back, the it actually mentions that the traceability clause, the information can be significant social media intermediary can be asked to decrypt the information on the basis of a court order or by a government agency. So even by an executive order, the information can be decrypted. Whereas in other countries, if you look at the international practice, some kind of a judicial order is required. So here we see that even by an executive order, the information can be decrypted. And the traceability clause is applicable only to a significant social media intermediary. And the distinction, as we notice, is only on the basis of a registered user base. Now what happens, the we may see that the unlawful activities which the wrongdoers, they may use the other platforms, they may do it on other platforms and not through a significant social media intermediary, because uh, these kind of clause, this clause, the traceability clause, is only applicable to them. So they may choose other platforms to bypass the law, and the unlawful activities or the wrongful activities, as we may call it, may still continue. And there is the traceability clause is not applicable to an intermediary. It is only applicable to a significant social media intermediary. Thirdly, the terms like the sovereignty and integrity of India, the security, the friendly relations with foreign states, and the public order, these are terms which are not clearly defined in these rules, and this may lead to harassment of these platforms by the by the law enforcement agencies, because the terms may be interpreted very these are very powerful terms, these are very broad terms, and there is an apprehension which has been expressed by the stakeholders that these need to be defined. And another reason which has caught the attention of many is the decision passed by the level 3 of the 3-tier structure, which we just discussed in detail. And the implication is that the decision passed by bureaucrats at the level 3, who do not have much experience, they can possibly overrule a decision passed by a retired high court or a supreme court judge who is at level 2. So now look at the interesting aspect of these IT rules. When the government, being at the top, they have assumed the function of the chief regulator, they can actually change the decision, or which has been passed at level 2 of a retired judge who has judicial experience. The government can actually overrule or change the decision which was passed at level 2. Now let us try and understand the reasons behind the criticism of the IT rules. These IT rules, within a short span of time, these were introduced in February 2021, and here we are in August. Within 6 months, we have seen a lot of litigation, and these litigations have spread in various parts of the country, and they have come under criticism from different organizations, for be it the news portals, the legal news portals, even the WhatsApp has approached, the has adopted the legal route, and there are litigations before the Delhi High Court, the Bombay High Court, Madras High Court, and the Kerala High Court. Now let us understand what are the reasons which led to this litigations being filed, what is the basic reason why this has become a subject matter of intense debate, that already within 6 months we have several litigations pending before various courts. And the key reason which has been raised in all the litigations, the crux, if we have to look at it, which of all the litigations which that have been filed before the various courts of the country, is the violation of the fundamental rights. And which of those fundamental rights have been violated? Now let us try and understand one by one which uh, 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 fundamental rights have been raised in the petitions which have been filed before the various courts. The Article 14, the right to equality, has been flagged. Article 19(1)(a), the violation of freedom of free speech and expression. And Article 19(1)(g), which talks about the freedom to practice any profession, occupation, or the trade. And Article 21 is the violation of privacy. The Article 21, basically this has been raised by the WhatsApp when they talk about the violation of privacy. The violation of privacy, it says that the end-to-end encryption, which the WhatsApp has objected to the traceability clause, which is under the Rule 4 of the IT rules. They say this violates the individual of the privacy of an individual, and and also this is in contrary to the landmark judgment which was passed by the Supreme Court in the case of the S. Puttaswamy versus the Union of India. So this is the crux. And another reason which has been raised in these guidelines is the unreasonable restrictions which these rules have these rules restrictions that or the regulations which they place on the digital news media agencies. They are actually ultra violence of the act. And basically the prime or the key objection which has been taken is the chief regulator, the role of the chief regulator which has been given to the government, and which the petitions say could this have been given in the first place when this was not the objective of the IT Act. The organization or the three-tier structure which has been established, was this a part of the IT Act? Could it have been established? Because the purpose when this IT Act was enacted, the objective was very different. And with the government being the chief regulator when it comes to resolving the grievances, so could these bodies of the grievance redressal, as the government has established in the three-tier structure, could these have been established? So these guidelines, so these litigations, they take a view that these rules are actually an attempt, to bypass the judgment which is delivered in the case of Shreya Singhal case. And in the Shreya Singhal case, this section 66A, the government had, the Supreme Court had actually recognized the free speech rights, over the internet, and it was declared to be unconstitutional, and it was eventually struck down. And recently we have seen in the news, the Supreme Court taking a view that why section 66A is being, still being used in the FIRs, and the proceedings under section 66A should not be, it should not be invoked when it was struck down about several years ago. So these litigations have been filed, these have been, as I mentioned, about the news portals basically, and the legal news portals. It has been filed by the Wire, the Live Law, and the WhatsApp. We have a Carnatic singer, and also another litigation which is before the High Courts is involving Google. This is before the High Courts, and the position which the Google has taken, it says that the IT rules are not applicable to them. And they say that these IT rules, they have actually misapplied the term. They are merely an aggregator and not the significant social media intermediary. Even it says it should be a resident in India, but it mentions the name of a foreign office, a foreign national. So these are the reasons, why these guidelines have been a subject matter of criticism before the various courts. And so essentially you can see this is the violation of fundamental rights, which has been raised in all the in majority of the litigations which have reached the various high courts of the country. So to conclude the session, we all need to keep in mind that no social media intermediary would like its platform to be used for criminal activities, and there are the concerns about the chilling effect of freedom of speech and expression are justified to some extent. So apparently there is a need to clarify these IT rules, so that whereby the individual the freedom is not curtailed. And we the stakeholders, there is the need of the hour is that the stakeholders should come together, whereby the interest of the consumers, the intermediaries are safeguarded, and at the same time the criminal activities, they are curtailed or brought down. So the this with this framework, the IT rules, it's a step in the right direction, but we all need to find a solution. The stakeholders need to come together, to have to take a balanced approach to deal with the issues in hand. Thank you.
Thank you so much, sir. This was really an insightful session. And we now like to invite questions from the audience, if there is any. Okay, so till they are typing the questions, I just have one question from my side. So, sir, as we all know that we are in an era of where we are living and breathing technological advancements, and the legislation is always trying to put a track on this whole mechanism. So, do you think this particular objective behind this rule can can put a harmonious balance between the right to privacy and the freedom of speech in the long run, as you know now, as per the critics and all, as we are seeing of these rules?
Yes, I think that these guidelines, this is a step in the right direction. So before this, there were two options. We had the self-regulation code, which these the players had enacted. This was an informal code, and with the rising number of complaints and with no institutional mechanism in place, this is in fact a step in the right direction. But at the same time, my view is that we need to take a balanced approach, and whereby the interest of the intermediaries are also kept in mind, and at the same time it does not curtail the freedom of speech and expressions of the viewers or the users.
Also, just to add on, so we have been listening that this particular rules could have a clash with the data protection laws in the country. So, what's your take on that?
Sorry, your voice, can you please repeat? I was not able to hear you clearly.
Yeah, am I audible now?
Yes.
Yeah. So the critics have been also saying that this particular rules could have clash with the data protection laws in the long run. So what's your take on that?
I think my take on that is that the data protection laws are yet to come. So let us wait and watch how these what provisions are actually kept or retained in those provisions. So till then, I think we should wait and let us comment when these actually the data protection law is actually rolled out.
Yeah, absolutely. So we have a question from one of our attendees. So Mr. Ashok Ram Kumar asked that, do you think that the certain provisions will meet the same fate as that of 66A?
Well, I think in my view, the IT rules are evolving. There's a lot of the time will tell what view eventually the courts will take. There is a lot of the clarification or the guide or the the guidelines or the changes or the comments which are which are coming on a daily basis. We so these guidelines are still evolving, and only the time will tell which way the route the courts actually take. So right now we are seeing within a span of 6 months we have already seen a lot of litigations. But yes, we are seeing social media intermediaries falling in line, uh, although there was initial uh, disagreement between the two, over how and over the eligibility criteria, how these appointments were to be made. But so let us see. At this stage, it is a wait and watch policy, and see how which way the courts actually decide.
I hope that answers.
And in my view, I think this the view the IT rules in the present shape, this actually gives more power in the hands of the government, in the grievance redressal, as we had just mentioned. In the digital ethics media code, the government is at the top level, so it actually gives more power to the government. And this actually has been the major point of debate between the social media intermediaries or the news portals, and this is where they are concerned that this will lead to this may have an impact on the freedom of speech and expression, because we they are concerned what the content may not actually pass through, because we have a bureaucrat sitting at the top. So this is so. Let us see how which way the courts decide. So at this, I think these are still early days, and time will only tell which way these litigations actually. But at this stage, the courts have taken they have taken the view that these appointments of the officials, the grievance officers, they have to be made. And at the same time, the courts have said that no coercive action should be taken against them till the time the matter is pending. So the litigations continue, but I think it will take some time before we have a final decision in place.
Yeah, and we have a follow up question from Mr. Ashok again. So he asked, should there be specific definition inserted to give more clarity to the terminology?
Absolutely. In my view, yes, we should have specific definitions. See, ultimately, India is a key market for all these social media intermediaries, and they earn a lot of revenue. And it is better we have clarity, so that these social media intermediaries know, and even the intent is made clear. When we have the definitions in place, then the scope for any confusion or a doubt being raised will be minimal. But with no definitions in place, the things, the apprehensions, as we may call it, they are bound to be there, because we do not know which matter or which clause or which action or which post may actually become a bone of contention between a government and the social media intermediary.
Okay. So he asked that, are these rules extended to intermediaries like Airtel?
Yes, these will apply to intermediaries.
Okay, great. Do we have any other question? Okay. So just to take up a last question, sir, this is from my side again. So as we are as we see that India is also emerging as a used platform for gaming industry as well. So now the gaming industry is coming up with an with technologies which somewhere is in line with the social media intermediaries. They are allowing the players to interact and to kind of provide a same platform just as the social medias are interacting. So do you think these rules will also extend to those gaming platforms?
Gaming platforms.
Yeah.
No, so see, these rules are essentially for these two categories: the social media intermediaries, the significant social media intermediaries, and the online news portals. So, in my view, I think these guidelines will not apply to the category that you had just mentioned.
Yeah, fair enough. So I think we have come to an end of the session. So before concluding this session, I just would like to inform you all that the IP Press is organizing a workshop titled Non-Fungible Tokens and its Impact on Current Intellectual Property on 14th of August. This workshop would present a wonderful opportunity to garner information and clear doubts concerning the concept of non-fungible tokens and related issues. And to register, you can just visit to our website. To conclude this session, I'd like to thank everyone for this wonderful and informative session. It was a delight to have you all with us today. And I'd like to extend my heartfelt gratitude to Mr. Abhishek Nangia for giving us his precious time. We could not have had a better speaker and a trainer for this workshop. Thank you so much, sir. And I'd like to thank the IP Press for this wonderful opportunity. And lastly, to all the attendees for making this session a fun and interactive one. Thank you, everyone. And just to conclude, we'd like to play a small video that we intended to play at the beginning. Just give us a second. Yeah. So with this, we end the session. Thank you so much, sir, for your time.
Thank you to the IP Press team, and I think it was a wonderful session. Thanks to all the participants for the interesting questions that they had raised, and it made the session even more interesting with the questions that were asked. And I think I would thank to everyone, to all the to you there, and the for the participants for the very interesting session. Thank you once again.
Thank you, sir. Thank you.